Read a second time. I call the member for Balmain.
Thank you, Mr Temporary Speaker. I rise this evening to speak on the Criminal Procedure Amendment Court Costs Levy Bill. As we've heard today, Mr Temporary Speaker, this bill provides for a compulsory levy on persons dealt with in summary proceedings before the local court and those that are found guilty or those found guilty under Section 10. The bill moves from the current discretion to apply court costs to an automatic statutory court cost levy that would apply to convictions, some of these Section 10s and to the local court. There are legislative exemptions, as we've heard other members describe, from the levy, where imprisonment is ordered, where Section 10s are recorded in the drug court for orders made under Section 10A, that's convictions with no other penalty, and traffic offences dealt with under the Children Criminal Proceedings Act, and there's also discretionary exemptions for children under the age of 18 years. The amendments will apply to existing proceedings which have not yet been determined by the time the amendments commence, and it also clarifies that the levy does not apply to the Children's Court, and this court will retain its discretion to order court costs. Now, there's currently power for local court to make an order that the defendant must pay court costs. It's generally the amount of the filing fee, which is $83, and the government's seeking, as I've mentioned, to make this compulsory. There are some issues I'd like to ask that the Minister address. And, sorry, I just listen to you all the time. That's all you say, anything I just jump. That we'd like to ask the Minister to address, in particular when it comes to the operational legislation about the costs involved. We understand at some briefings and in other places that these reforms, based on 2010 figures, have the potential to raise around about 7.7 million. I understand, of course, it's difficult for the Minister to provide an exact figure because local court magistrates might choose to exempt children that appear before them, for example. The levies may be made inapplicable if the court has chosen to deal with the defendant under the Children Proceedings Act rather than the law. They might be written off, they might be paid over a long period of time. We understand that, and we've been advised that that might be the case. But one of the issues that I think is worth the Minister discussing is that we're told that at the moment that existing orders to pay levies, so these are the discretionary levies that can be applied, that these issued at the discretion of the court are recovered at the rate of about 25%. About 25% of all issues ordered in the first year after the issue of that order. So the recovery rate isn't particularly high. And at present, magistrates order court costs in about 50% of cases. So 50% of cases in the first year, only 25% recovery. So if you look at the 7.7 million figure, which is the absolute maximum that could possibly gain from this, we know that in the current environment, only 25% of those monies are recovered in the first year after the issue of that order. And the question is then, well, what's the cost of this whole system? If so many more of these notices are developed, if they're issued, if they're sent out, will it be revenue neutral? Is it designed to generate revenue? It's just that type of information I think would be useful, because we know at the moment, if you have a look at the annual report of the Department of Finance and Services, the cost of actually recovering a under $100 fine is in excess of 10% of the cost. So if we have so many more costs, so many more of these levies applied, and we know that only 25% in the first, that only 20, I'll make this correct, that there's a recovery rate of around 25% of all orders issued in the first year after the issue of order, then it may well actually cost the government. It may well cost the government more to manage and develop this system than it is to actually recover, at least in the first year. So I just think that's something that would be worthwhile that the Minister might like to address. I acknowledge the reasons why the government is doing this. They're doing it because I think that costs that are incurred by people that are found guilty under specific and limited circumstances should make a contribution towards that cost. But let's have a look at the actual numbers and see whether or not, on this information, I think it's unclear whether or not there actually will be any significant revenue generated, considering the costs, because it is a question about, of course, not just the administration of the cost for fines, but also the role of the State Debt Recovery Office and the role of the SDRO in terms of their costs as well. I know that there will be some efficiencies because the levy might be in addition to any other penalty imposed on the court, and that will be sought to be, gained at a whole. But Mr. Temporary Speaker, I think it's worthwhile for the Minister to address that. We've heard that there are a range of measures that have been included to make sure that if there are instances where people are unable to pay the levy, they'll be subject to some options. And we know that the challenge of the WDROs is that people don't know that they're there, how do they use them, and so the issue about potential options to actually increase the profile of options that are available to people would be useful for the Minister to address. The current exercise of the court's discretion may serve to protect some of those who would be unable to pay fines, and so the discretion of the courts, in my view, is something that is generally better left to the courts to be able to exercise rather than to have mandatory payments. I understand that the courts in particular instances did determine, or may determine, that people would be unable to pay fines and simply exercise their discretion. And that is probably a more useful process rather than engaging in a very long-winded, expensive administrative process of determining down the track, well, actually, we'll just issue a WDRO because we know the person can't pay. So surely at the beginning of the process, the discretion of the court may well be more effective from a financial perspective than from the universal, with exemptions, but the universal application of this levy. There are a few questions, Mr. Temporary Speaker, that I'd appreciate if the Minister could address when the Minister sums up and concludes. But I thank you for the opportunity to make this contribution.